Hello there, everybody. How you doing? Gonna play a little something different, a little something special tonight. Some of you may recognize it. It's a little ditty called Disingenu-Wisconsin.
They say that Stephen lured her to the yard and T.H. had no address. Bliss colliding court, but Teresa, she surely did not have to guess. All those voicemails to the zipper, somehow Jacobs lost them all. But one of them turned out to be a replacement for the younger call. In this case, we surely see a wicked voicemail gate. These kind of things can only happen in the state of Disingenu-Wisconsin. They said it was too dark to see any blood in the car at Avery's yard, but they were able to read the text on that teeny-weeny SD card. They said because it's locked we cannot explore inside of that RAV4. When it arrived at the lab, they suddenly Sesame opened the driver door. How it got there, wrong way round, that does need no debate. These kind of possible things only happen in the state of Disingenu-Wisconsin.
I love it, Roll. I love it, dude. And it was perfect for this video. For those of you who've seen the name of the video, you know why I wanted to choose that little ditty. So trust me, this response that we're going to look at today is just disingenuous from word one till the end, in my opinion. There might be some law in there that maybe has like a leg to stand on somewhere, maybe in an alternate reality somewhere. But it's really just, they're just mainly sticking. I would say they actually approached the substance of the arguments in this one. I would say maybe, but not really dealing with it very well. When you guys see what they said, it's just bizarre, really. So, how you doing there, Trav? Good to have you.
Doing good.
So, now those of you who remember the last time when we were covering Kathleen Zellner's motion that she filed regarding, with the circuit court regarding this issue of the bones and the statute violation and the potential due process violation, when she filed, you remember Tracy and Travis here were critical of the fact that she had asked for the judge to recuse, right? They thought that was not good because it was not the time for it, and it just gave the state something easy to pick at and attack, that sort of thing. Well, that's exactly what they did at the beginning of this motion. Before they even get to talking about the bones or procedurally barred from this and procedurally barred from that and procedurally barred and barred, procedurally bar, here, there, and everywhere, right? Before they get to all that, they actually address the whole, recusing the judge thing. So it's pointless. They're just basically saying it shouldn't happen, like basically just, stroking, Judge Suck at this, basically, essentially, right? So that's why they open up with it, right? Makes sense to me, right? Anyways, the other thing about this is that we don't even know that Judge Suk has asked for this. We don't see anything anywhere where she's officially asking for this response. So it's also interesting to think, what is it? Were they asked to file this response, or did they just want to file something and hope she would read it? You know what I mean? I don't know. Anyway, we basically what I'm getting at though is we don't know if this response was asked for. It could just have been offered, and it could be that a little on down the line here that Judge Suk may make her decision and say the same thing she said last time. The state responded, but I'm not looking at that, and there's a reply, and I'm not looking at that either. She might do that same thing again because we see nothing where she's asked for this response. But hey, it's here. We're going to take a look at it. Anyway, you still there, Trav?
I'm here.
Okay, just making sure. We lost your video.
I switched over to watch the chat stream, and
Oh, okay.
evidently when I do that, it turns my camera off because I'm on my phone. So I just won't watch the chat stream, and then everyone can see my smiling face.
Right.
Maybe they may vote for me just to stay off camera. So we'll see. But yeah.
So somebody has a question about the word cognizable. So when we get to that, or where that comes up, if you could kind of give people a little bit of a explanation as to what that means exactly.
I'd be happy to, but I fear it may become another catchword. But
that's what they're asking, if it's going to become another disingenuous.
Well, it depends if you bastardize it again. You bastardized
I didn't bastardize
into disingenuosity.
Disingenuosity.
But we'll just see. I think you left specious alone for the time being.
Oh,
We'll have to wait and see what you do with that.
Oh, right on. Let's see. Because they're making fun of you because you had your anyway. That would be better. Oh God, you guys are mean. You guys are mean. Anyway, no. Okay, so moving on to it. Like I said, the beginning of this response is basically them saying, "Oh, this recusing the judge stuff is just ridiculous." Blah blah blah. Whatever. It's it is what it is. They're just saying that shouldn't be whatever. Giving their argument. Then it moves on to talking about. Hold on a second. Basically the preservation and the disposition of the bone fragments, and it basically goes on. The first couple pages they're just basically saying how Stephen is procedurally barred from bringing this claim, essentially, that it could have been raised by his appellate attorneys back in like 2011. The ones that they were hiding all this stuff from, right? Remember those guys back in 2011, right? So it could have been raised by them, even though the stuff was being hidden from them. Then they're saying that, I believe if I'm catching this correct, they're saying that when one of Kathleen Zellner's team did the FOIA or FAOIA, Freedom of Information Act, FOIA request, and got all that new queso stuff, that apparently that came along with that, they're saying, was all the final pages of queso, the pages 1014 and 1015. That they're saying that came along with all that stuff, and that it should have been noticed then. It's like, here's a question, Travis. You're a lawyer. What is really reasonable to expect a lawyer to catch? How quickly? I mean, something like that buried in mountains of paperwork. What's a legal standard of what is like a reasonable amount of time for it to have been reviewed, gone over, and caught? What would the courts deem as like a reasonable amount of time?
Well, a case, it depends on the timing and the volume of the documents.
Right.
And we've got thousands and thousands of documents, thousands that were just part of the discovery the DA gave pre-trial.
Right.
In just Stephen's case. So now, what did they say? So
you're saying that in 2018,
the defendant's experts, our defendant's investigators, it's Darby and Darby, right?
Right.
Made a request in 2017 under FOIA.
Right.
I don't know when in 2017 they said, but and then they're in the middle of this computer dispute on the computer CDs, and there's a response that's required back. They don't come out and say this request should have been done when the day Zellner got involved in the case. They're trying to twist this around,
right?
Obviously. Now, reading that part was a little bit troubling to me, because her her preliminary motions going back into February, what got the ball rolling. I think she was pretty clear that neither her office nor first post-conviction or the direct appeal counsel had any of these updates when so they're deflecting. Clearly, it's going to be interesting to see Zellner's reply. They will get to this later, but they're not, they don't, they say it's the two lawyers that were there when they gave the bones back or helped select the bones say it's inexplicable as to why they were returned to the family. And they're trying to soft pedal it by saying for burial. It's not that they violated the statute, but we'll get to that. They have a very strained reading of the statute, but so to get to your original question, it's not so much that it is.
Not to mention the fact she wasn't expecting that there were going to be extra pages of the original investigation reports that she didn't have, right? When they got that, that FOIA request, whatever, right? She couldn't have honestly been expecting that they were going to be giving her pages held back from the original. You wouldn't normally assume that, right?
But I don't know what these other 54 pages were. Are you able to figure that out?
Oh, I've done videos on it. Yeah, it was Dietering going around and interviewing.
Dietering is with the AG's office, right?
I think he was a Calumet investigator that they brought out of retirement to go do this because he was the guy that originally went down around and did the interviews. Right. So I think they wanted a familiar face. This
is the interviews at the Subway shop with.
Yes. That's one of them. Yeah.
Well, see, that's very odd because they're talking about that's what I didn't understand. They made a request on Calumet for open records. And we know CASO is pretty much 1,117 pages,
right?
Which is exactly what they had. And they talked about this other 54. Now, I could see the AG having post-conviction records, but why would Calumet have it? Now, I don't know who they served that on. It talks about it in the motion, and I didn't pay attention to that. It's in their response when it talks about 54 pages. They even specify, 1,017 pages at 25 cents a page. What does it say? Who does it say they served that FOIA on?
It says they served it on the Calumet County Sheriff's Office Department.
Okay, so why would they be serving? Well, my understanding always was that Dietering was doing it. Yes, he was retired, but he was doing it on behalf of the AG's office, not Calumet County. I may be wrong on that, but that's what we're assuming the 54 pages are, right?
Right. Well, it's going to be the new investigation, right? Where Dietering went around after Zellner filed her MPCR. Basically, in November, following that's when this new investigation opened up, and that's when we got these new 54 pages of Dietering going around and interviewing people. One of which is Mike Halbach. He goes and he's basically desperately pleading with Mike Halbach to please find some picture of the RAV4 damaged on one of his old computers so that they can prove it didn't happen the 31st. Literally, that's what it was like. That's what it was about. They're talking to Mike, desperately hoping he'll come up with an image from one of his old computers proving the RAV4 was damaged previous to the 31st of October 2005.
Yeah. So I would, we do it a little bit different here. We wouldn't be having our investigators send Freedom of Information Act requests that the public can get. We would be sending requests to the AG, whoever the attorneys are, saying, look, the latest version of the offense report, investigative report we have is dated whatever and consists of 1,117 pages. Pursuant to Brady, and in order for us to, effectively represent our clients, we want anything from the investigative report that's been generated since that date.
Right.
And we basically sent them a whole discovery list saying, we want to know anything that you've done. Have you run prints through CODIS? Have you resubmitted the DNA profiles to see if there's a match now? And then, we request they do other things. And then if they don't, then we, try and exploit that to our advantage if we get an evidentiary hearing. But so they did it under their open records law in Wisconsin. Now, is your reading of the motion, they talk about that they billed for the 1,117 pages.
Right.
And it was $250 some odd dollars and cents. And they did the math.
Yeah, 279.25.
Then they footnote, I believe they footnote and talk about 54 pages that at the time it was requested. We did the bill, and then it talks about 54 pages. Is your reading of it that they turned over the 54 pages, or that?
Well, that was the 54 pages was the FOIA request. That was the request. Well, a request was made for anything new, and I guess so. The final pages of the previous case came along with it, I think is what they're saying. Let me see here. Certain bumper of the report dated. Pages. Current post-conviction counsel acknowledged receiving the investigative reports on or about May 30th of 2018 in her motion to compel production of recent examination of the DASI computer filed in this court, blah, 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 blah. Armed with this additional information, so it's basically saying that those pages, I think, were handed over with the FOIA request here. Hold on.
I didn't read it that way. I read it that they made a request for all investigative reports. They billed them.
Investigative reports, that is here. It just so happens that what came out, I guess what the problem we're having here is that what came out was, any of us would have saw the final pages of the case and we'd been like, yeah, seen it, been there, done that. We would have moved right to the 54 pages we hadn't seen, right? So I think that may be why we didn't realize.
Okay.
Otherwise, we might have been able to go, wait, why are those 3 pages? I mean, now knowing what I know now, I would go, wait, why are these 3 pages here? Right? Now I would be like, oh, wait, that means that somebody didn't get something previously. Now I would put that together, but then I wouldn't.
So the bottom, so what they're doing here is they're trying to shift this up to the other foot because Zellner spent a significant amount of time going through obtaining affidavit from previous post-conviction counsel about, was this stuff contained in the offense report, the investigative reports, when, you were representing Stephen, and they got an affidavit from her saying, Hagopian. No, we didn't have this. And now it's like, the state's come back and said, so what? You had it in 2017. If you're going to request this stuff, you better read it. So Zellner is going to have to come back and explain a little bit about that.
Well, I mean, to me, even knowing that those were given back then at the time, I mean, she didn't know that the new quick DNA method was in existence yet. So she wasn't asking for the testing. She wasn't pushing for the testing yet. It wasn't until she found out there was testing that could actually possibly help, then she started filing it, right? I mean, I don't know. That's the way I see it.
No, that's key. And she, as soon as that rapid DNA testing became not available, as soon as it became apparent that it might be able to test burned calcined bones because of the California fires, I think we were within 30 days that she had an affidavit from her expert. He had gone through the bones, the photos of the bones. He identified bones that he'd like to test. And she filed that motion for new DNA testing in December, which, got denied. And, but that
microscopic testing, right? That was going to be inferior to the testing, but
no, just December 2018, when we figured out.
Oh, all right. Yes, sorry.
He had returned the bones. It was because of that motion for
Quick
rapid DNA testing.
Yeah, right.
And the point being, she requested that surprisingly quickly. It wasn't until the California fires that it was known that rapid DNA testing might be able to detect DNA in burned calcined bones.
Right.
Because these bones had been sent to the FBI previously, and they said, we can't test these. Now there's this new technology, and the Wisconsin DNA statute is specific about, hey, if new technology is developed to test, you can ask for testing at any time. So the point being, she asked for that right away. Then they didn't, the Court of Appeals denied that. Then she says, hey, I learned that, through a civilian source that these bones have been returned to the family. We never knew that. And now that's a violation of the statute. But you mentioned, or somebody mentioned, smoke and mirrors. Here's why that's a specious and or disingenuous argument by the state.
Mm-hmm.
The question is, back in 2011, right, when these bones were returned to the Hallbach family, at about 2011, correct?
Yes.
Going on 8 years. It was after the motion for new trial had been denied. At the end, the state mentions it in this response. The question is, was it either bad faith under Youngblood in 2011, or was it a violation of the evidence preservation statute? The statute puts all the duties on the state. And we'll get into that a little bit later, in the arguments under motion, but
so it's just about how that's unreasonable.
Well, they're deflecting and saying, well, she should have brought this in 2017, not in 2018. I guess they're still reeling over how long this appeal has been languishing.
Languishing, yeah. Yep. Sorry. Okay, so the next bit, let's see here. They talk about appeals in the scope of remand order. Okay, so it says that they could have filed a motion in the Court of Appeals asking leave to expand the scope of the remand order issued by the Court of Appeals. But then, like I said, they still didn't have the testing back in. Everything hadn't come back together back then, right? So it seems silly for them to argue that. Next thing it moves on to is, even if the claim is not procedurally barred.
Hey, well, wait, there's another part in there that they mention, and I think it's, just one sentence. It's kind of like a byline, but they reference the first post-conviction motion for relief, which was filed pro se, and they mentioned that specifically. That's the one that Stephen filed and Zellner dismissed because it was all messed up. And they're claiming a procedural bar because of that. And that has, I don't know if you can find that real quick and read that sentence, but that has been a concern of Zellner's from the beginning, and that has been a concern of mine and Tracy's, what is going to be the significance of her dismissing that pro se appeal that Stephen filed in order to pursue the additional testing, and then file a new motion for post-conviction relief.
Well, there is this paragraph where it says the purpose behind this rule, which is talking about the sufficient reason rule. Anyway, the purpose behind this rule is clear. The promotion of finality in the criminal litigation by requiring defendants to bring all available grounds for relief in a single post-conviction motion or appeal, unless there are good and sufficient reasons for not doing so. There is no dispute that Avery had a direct appeal. There is no dispute that Avery's filings are successive and repetitive.
There's dispute on that. I was
going to say
that's a pretty silly statement that they made right there. But go ahead.
I was going to say that seems highly disputed to me. But anyway, there is no dispute that Avery has chosen to take a piecemeal approach to collateral review. Once again, is that not disputed, folks? God, I dispute that all day long. Are you freaking kidding me? Piecemeal? Look, this is the state again trying to say that Zellner is wasting everybody's time. Okay, look. How can Zellner bring everything together under the MPCR? This is how disingenuous the state is, folks. How can she bring all of these things together under one motion for post-conviction relief when the CD and the Brady violation was put into her lap after it was denied, right? Then these pages of queso pop up, after it's denied. It's not piecemeal. She's filing it as she discovers it, literally. And like I said, it's not her who chose to give herself that CD after the motion for post-conviction relief was denied. She didn't choose to do that to herself. The state did that. Okay, so that's for me one of the big reasons why the state is very disingenuous. And when you read stuff like this, that's just one thing you can think about that's very similar to the arguments they're making here in my mind.
So, and then it's interesting, Fallon and Gahn signed this appeal because it's back in the circuit court, the trial court level,
right? And
there's two other attorneys that are handling it in the Court of Appeals. One's, Tiffany something, but
right.
They're kind of making the opposite argument that Tiffany was. Tiffany went with this, well, you can dismiss your appeal and you can go forward with this. Of course, she kind of mentions in passing, but in a very disingenuous way, but she doesn't say it. We knew it was going to be this King's X game with them that, dismiss your appeal. Go ahead. And then you go ahead and do that. And then they say King's X, it's procedurally barred, and so not only have you dismissed your appeal with all these potentially meritorious arguments on Brady and ineffective assistance of counsel, you were procedurally barred on the bones anyway. And Zellner's just always said, hey, we might as well just bring it all together. And, but, they're making highly technical arguments on appellate procedure. They're not discussing the relative merits of, they want to avoid the merits of the facts that have been developed and the investigation. They want to stay away from that as far as possible because that doesn't benefit them. That doesn't, those are the facts that cry out that, there's injustice. That, look, what the state's narrative was at the time of trial has been proven to be false because of these things that we've developed.
Right.
That's an injustice. And we'll save that for the end. I want to come back to it, make a note here. But for those of you who watch the Adnan Syed 4-part series on HBO, you're going to know what I'm talking about. The state they didn't want to talk about all the facts that were developed. They wanted to talk about the hyper technicalities of Brady, whether you need to, or of ineffective assistance of counsel. Do you need to run down an alibi witness? And, we'll talk about that at the end, but you're going to the next section. But I did want to point out, they allude to a procedural bar because of the dismissal of Stevens pro per motion for post-conviction relief. And we've always been a little bit worried about that. What's the next section?
Okay, so the next section is even if the claim is not procedurally barred, it cannot be raised under Wisconsin Statute 97406 motion. And here comes that word we were talking about earlier, where it says a petition under Wisconsin Statute 974.06 is limited to jurisdictional and constitutional issues. Avery's motion for new trial based on an alleged Youngblood violation must be denied because he has no cognizable constitutional or jurisdictional claim. At best, he has only a statutory claim, and that is not enough. So cognizable basically just means
recognized.
No recognizable,
recognizable claim in the context of
derived from the word
constitutional claim, that a statutory, that this type of violation is not recognizable as, what did they say at the beginning? A statutory claim is not recognizable as a constitutional claim. Therefore, you can't bring it in this type of motion.
Right. And if it was just a statutory claim and they hadn't been trying to hide what they'd done, that might hold, right? But because they were trying to hide what they did, that brings in the potential due process violation, right?
Yes.
Right. So that is constitutional, right?
Yes.
Right. So there we go. So disingenuosity of the state, folks. Just pointing it out again. Now, the other one I pointed out here is on page 8 here, where it says, Osborne sought access to the state evidence so that he could apply new DNA testing and technology that might prove him innocent. Osborne claimed he had a due process right to access evidence during post-conviction proceedings so that he could do short tandem repeat, basically DNA testing. Osborne asserted that such testing was more discriminating than the DQ alpha or the RFLP methods that were used at the time of his original trial. However, the Supreme Court rejected his invitation to recognize a freestanding liberty right to DNA evidence testing in his post-conviction proceedings. Osborne at 72, the court determined once a defendant has been proven guilty beyond a reasonable doubt after a fair trial, he does not have the same liberty, interests as a liberty or interests as a free man does. If the Supreme Court had concluded that there was a due process right, the court would be short-circuiting the many considerable legislative responses being adopted throughout the country by state legislatures to handle post-conviction testing issues. The court further opined in
Okay, stop right there. All right. So what they're saying is, and this hasn't come up yet, but I've been wanting to get this in.
Mhm.
So you've done some great segments on AEDPA.
Right.
On your channel. I've been a part of one or two, and you've done several long before I was around, and you've done, I think, another one here recently.
Right.
And understandably, there's a lot of frustration with your subscribers and people in the public in general that, a terrorist act led to this legislation and eroded our rights under the great writ of habeas corpus, supposedly in death penalty cases to speed up death penalty cases and appeal, under this guise, and it, what the devastating effects it had in Brendan's appeal.
Right.
And so what they're talking about, they're talking about federalism, the power of the federal government versus the power of the states, the power of the people of a state to control, how their justice system is going to work versus what the federal government, how the federal government thinks the system should work. And so it's this state versus federal type thing, but they talk about state legislatures, amending their statutes on post-conviction relief. So what they're talking about is 974-06. Before 974-06, Wisconsin had like all states, a general writ of habeas corpus. And you could have your appeal and then, file a writ of habeas corpus. Then they enacted 974-06. So this is the point, I'm glad they mentioned that in their brief. 974-06 is Wisconsin's version of EDPA. And you can tell by the wording of it, what you have to bring, when you have to bring it. 974-06 is writ of habeas corpus reform. And
Okay.
it's part of this stacked deck. It's part of this stacked deck the state has on this post-conviction relief. And it's why things are so difficult. And this goes back to when people were getting frustrated with the way things were being appealed and, things were being supplemented and so on and so forth. Well, you have to do this. You have to, as soon as you discover something, you got to file a motion to supplement the appeal. Kathleen won on that already down at the circuit court on the computer disk. Second this denied it.
Right.
And then, the Court of Appeal said, whoa, wait a minute, it's not that hard to figure out. Just, we're retaining jurisdiction, but we're sending it back on this limited issue. And we'll go into what happened from there. I don't know why the state filed this response, but we'll get into that a little bit later. But, so now, they're going back into the technicalities of it. And it's like the technicalities of EDPA that, it's not clearly against the weight of constitutional law found, by other circuit courts, and how they limited after EDPA, how the circuit courts, the federal courts, limited what you could do in post-conviction writs. Well, here's an example that the state's trying to argue that, well, you can argue young blood, but you can't argue this specific statute we have in Wisconsin about preserving biological evidence. Even if you find out about it years later, even if we allow you to test under our statute years later, and then you discover we destroyed it, no, you can't bring a post-conviction motion because it's limited to,
Right.
it's just this hyper technical.
Which is what I wanted to say about this. Essentially, what that paragraph says is the state is saying that once we've screwed you, you're screwed, and we can keep screwing you. That's essentially the way that reads to me. So now that you've likened it to AEDPA, that makes sense to me.
No, I'm not saying it gutted.
No, but it's setting that high bar, right?
But yeah, EDPA, totally gutted the Great Writ.
Right.
And then, but one of the things it did is that EDPA said you only get one federal writ of habeas corpus. Got to bring everything all together, and then that was in the body of the statute. Then the case law after it said, oh, and we're going to shrink it down to just these narrow issues are the only, a state court has to really, really mess up. It can't be a little error in constitutional law or a minor due process violation. That's kind of like, I guess, a little bit pregnant, but
right.
It's got to be a major due process violation. That's what the court said, and so it really gutted the Great Writ. Now, in Wisconsin, I can't tell you. Tracy would have to, maybe more of a history when it came in and whatnot, but you look at the language in 97406, and it's really specifying what you can file. And when I was reading it, I'm going, oh, well, this is their state version of EDPA. It's post-conviction writ reform. You got to bring it in one motion, one time, which is really unusual. I'm betting that 97406 came in before they've abolished the death penalty in Wisconsin forever.
A long time ago, yeah.
Yeah, the 40s. I don't know why they did it. It's just amazing. Who cares? You get somebody with a life sentence or life without parole. Yeah, they should have to bring it all at one time. But, if you find new stuff during the process, who cares if you supplement or amend? It shouldn't be that big a deal.
It should be open to getting it right. I don't understand why there's such an aversion to that. It's really a problem for me.
I could see the arguments on the other side, not in this type of situation, but let's say Stephen had filed 3 on his own, were worthless, and then he got a lawyer, and that one was worthless, and they got another lawyer and basically filed the same thing 5 times, and then they got Zellner, who knew what she was doing, and then filed something new. I could see that, but they didn't have to respond to Stephen's first motion. Zellner dismissed it, went with the additional testing. They're not having to respond to appellate briefs over and over and over again. The brief hadn't even been filed yet. That's why Zellner is extremely careful about making sure every possible issue is preserved before her brief has to be filed. This is exactly why.
Yeah. It makes sense. I mean, and the way that the state is holding stuff back, she'll never know. How could you ever be confident going forward with this appeal after what you've already experienced in the first year and a half, with two pretty majorly significant things cropping up after your motion had been denied, right? I mean, that's just amazing, amazing, amazing. So anyway, all right. So the next one that we move on to is even if Youngblood applied to post-conviction, which it does not, according to the state, Avery has not met his pleading burden. Two United States Supreme Court cases, Trombetta and Youngblood, are basically the ones they use to administer the testing or the test on this to see if this meets the requirements, right? So under Trombetta, due process is violated when the defendant shows that the state lost evidence before trial. That might be expected. So that before trial, that would probably be a different situation, right? So that's why we're not using Trombetta, right?
Well, no, and she'll cover this in her reply, hopefully. Tracy's done a really good video that she uploaded on the Youngblood and Trombetta cases and the distinguishing things. And you also did a video that she and I were both on, and she goes through those cases in absolute detail about one having certain requirements and the other having certain requirements.
Right.
And for those that are interested in those super technicalities of those cases, I invite you to go to Tracy's channel, and you can see her video on it, and they can let you or one of your mods know, and I can dig up the video in your channel where Tracy talked about that. Again, they were done on the same night, and
Right.
I believe it's back in February timeframe when she filed the original motion in the Court of Appeals.
Right. I believe that's right. So yeah, so those of you who are interested in some of the more technical stuff with Trombetta and Youngblood, we'll post a link, and so you guys can go see that, where Tracy will explain that in more depth for you. One thing I want to point out here, bottom of page 10, that I made note of is the state is criticizing Zellner that she's changing her theory. Okay. I would argue that she is including every theory. I would argue that she's throwing everything in, including the kitchen sink, because she doesn't want to get down the road and find out she needs it. Right? Look at how keen the state is to procedurally bar everything. What does that tell you, folks? If she doesn't mention it, she loses it. That's what they're making clear. I mean, half of this flipping document is making it clear that if she doesn't do it in a timely manner, doesn't do it exactly just wait, hopping on one foot and looking to the east and whatever, all kinds of bullshit you got to do, right? That's what it's like. If you don't have everything just so, you're barred. That's it. So she's including everything she can, in my opinion. And that's, for me, not changing theory. It's just including more theories. That's the way I look at it. Any thoughts on that?
No, well, when we're about halfway, 3/4 way through the motion for post-conviction relief, we were doing slide presentations on, and we mentioned this, that we talked about that the motion for scientific testing discussed suspect A and suspect B, which turned out to be, if you knew the case, you could easily identify one as Redant and the other as Ryan. And then she starts doing her investigation, so that's as part of testing. And then she gets her testing and files her motion for post-conviction relief. This is just stupid argument by these two boneheads. And she gets the testing back, and it shows, plus her independent investigation, she pretty much eliminates Radon.
Right.
This is kind of like, why don't you just dismiss the case, and then, the state gets bitch slapped by the Court of Appeals in the order granting the remand and the supplemental and the stay in the remand to allow this supplemental motion that we're going through now. They bitch slapped him. Why would you even suggest such a ludicrous thing? And this is another example of them being cute, and it's stupid, because she explains that after investigation, after the top experts in the country, most knowledgeable experts in the country have looked at this, we're now able, and going back to your, they're hiding stuff.
Right.
Now, now that we've talked to him and determined that he tried to explain all of this stuff to a state investigator at the command post, and they kept asking him, okay, now, how high did you say the fire was? It was a burn barrel, right? And he kept repeating, I can't tell you if it's a burn barrel. I can't tell you if it was a bonfire.
If it was open air, he felt it looked like a burn barrel fire. But
I could tell you the direction. I didn't see the flames. I can't tell you how high. And he finally gets so frustrated, and that guy, you're not going to get pushed around. That guy's no Brendan Dasney, Mr. Radon, with his lawyer with him when Catherine shows up.
Right.
He's a very successful businessman, and he's not going to take any shit. And he's like, well, he finally says, what do you want me to say? What do you want me to write? Well, I just want the truth. Well, I've tried to tell you the truth 4 or 5 times, but you won't accept it.
Right.
And she gets an affidavit to that. So talking about trying to hide the story. So what do you think happened when you have a 16-year-old boy and they try that stuff? Well, we saw the results of that. What do you think happens with somebody like Brendan's brother? And they come in and start saying whatever they're threatening him with, and anywho, so she explains then, when she files the actual motion for post-conviction relief, she doesn't abandon Ryan like the state's pointing out, suggesting in the section you just quoted from. They said, there's 2 other people were suggesting. What the state's doing is they're trying to rekindle this rift between segments of the family, and they're trying to rub salt in that wound, and they're trying to reopen that wound, and by the same token, they're trying to minimize the great schism that I've said could happen between the AG's office and the Hallbach family. And, you go through that bone section, and, if you could just put yourself in a place where, Michael Hallbach's reading that, and or his half brother, who's a lawyer, sitting back and reading that, and reading it from their viewpoint, and going, wait a minute, I heard you guys in closing argument, and what you argued in closing argument, and what you said about those Quarry bones, and then we don't know all the underlying communications, what led up to getting those bones later. They seem to imply here that the reason why it was 2011 is they were waiting for this direct appeal to conclude. But, they just make a lot of weird arguments in this section. They're talking about, the evidence preservation statute, and they're like, well, surely this can't mean we have to preserve everything. And, well, yeah, it does. It says to prevent that, to prevent having to preserve a ham sandwich. Jamie, did you catch that? Ham Sammy? Or a pizza for 40 years in an evidence locker. Right. You just send a letter to, you send a letter to the lawyer or the convicted defendant. Say, hey, we're going to get rid of this ham sandwich, unless you let us know. Mm-hmm. And so, yeah, that's what the legislature intended. If, you collect samples, anyway, I could go on and on and on about, the really stupid arguments about now, right. The technical argument, whether you can argue a statutory violation, Zellner's just going to have to contend with that and sort it out. Tracy's been concerned about that, but she knows of cases that she doesn't think that's a very strong argument for the state, but I'm sure it's one that they're hoping they can blow by Judge Angie, but they do not want an evidentiary hearing. They're doing everything they possibly can to avoid a evidentiary hearing. Right. Personally, I think they've opened themselves up. Tracy predicted they would not file a response unless requested to do so by Angie, but they just dropped this. Right. And I think in a lot of ways they've said things throughout the brief that it's really going to require an evidentiary hearing. Yeah. That's the one saving grace is a lot of their technical arguments require facts be known that have to be developed in a hearing. So
there you go. So either way.
Yeah.
All right. So one other thing here, folks, it's interesting. It's about the bones they gave back. They're discussing about the bones being given back, and that sort of stuff. I just find this interesting. So it is also worth pointing out that in comparing the evidence ledger sheets with Deputy Hawkins' report from the events of September 20th, 2011, there are many fragments from the quarry that may or may not be human. You got that right? May or may not be human, folks. Okay? All right. Still in evidence available for testing. Thus, Avery has also failed to establish that he cannot obtain comparable evidence for testing. I'll tell you what, I really don't give a damn about the bones you guys passed over when you were looking to give back the hall box, the remains of Teresa. I really don't care about the ones you left behind because obviously you think they're not Teresa's. No, we want the ones you determined were Teresa hall box bones. Those are the bones we want. But obviously the court may decide these other bone fragments are sufficient. I don't think they are. If the state decided not to give them back, that tells me the state has reason to believe they're not Teresa's. So that's just the way I feel about it. Any thoughts?
Well, I mean I think you said it all right there. But it goes back to what we've been saying throughout. They're hiding stuff, and this is another example.
Right.
I got some other thoughts about the timing of things that Zellner did, but we'll save that for another time. Okay. I need to think through it, but it's
Yeah, so then they go on to say that the potential usefulness of this evidence, these bones in the quarry, are, it's debatable and whatever. Well, that's what an evidentiary hearing's for. But anyway, the point is, and this is what the state doesn't want to touch. The fact of the matter is the state said to the jury, because they were worried about the jury believing or buying into Dean and Jerry's theory that the burn had actually happened over in the quarries, essentially, or the Manitowoc gravel pit, Kratz said, I'm not even going to spend 20 seconds on those bones. because the best that can be said for them is that they are possible human. So that leaves the question, what is the state doing giving back merely possible human bones to the Hall box? And how, I mean, and are we all really supposed to sit around and go, oh, okay, maybe those weren't Teresa's bones you gave back? I mean, are we really supposed to believe that? I mean, I feel sure that they felt sure the bones they were giving back were actually Teresa's. That's me. I don't feel like they would have bothered giving back bones they didn't think were Teresa's. And that's why I say the bones that are left behind are questionable to me, because not even they didn't think they wanted to give those back to the Hall box, right? So, but
really the only other big thing, they're arguing about the bones, and we predicted this, and we knew this was coming, was the materiality. And their basic, the main thrust of it is, and they concede, hey, even if these are Teresa Hallbach's bones, even if they are proven to be human, even if they are Teresa's bones, and they quote half a mile away, it's not evidence of his innocence. And we already know what Zellner's response is. Only an idiot would plant bones
in his own doorstep.
Right. And of course, this ignores the fire experts that the primary burn site was not the fire pit behind the garage. It was some other location, and therefore, there's no way to nobody would plant those on their own property or put them in their, put electronics in your own.
You wouldn't burn a body and start carrying it all over God's creation with you and dumping it around places and stuff. You just wouldn't do that. Right, folks? I mean, if you found yourself in that position, you certainly wouldn't be advertising it. You surely wouldn't want to be running around and walking around and where people could see you with a burning barrel and body parts hanging out. You certainly wouldn't want to be advertising that and running around with something like that, right? So you would most likely pick a spot, try to stay hidden until it was done, right? You wouldn't be carrying it around quarries and all over your salvage yard. Anyway.
And so, so this is going to come down to a big fight, probably in the Court of Appeals and then possibly up in the Wisconsin Supreme Court. But, the flip side of the argument, Falcon's talked about it in the past very ably, and other people have talked about it very ably. There is a counter argument to that the state's going to make, and they're going to use pure analytic logic that, if you took geometry, you studied part of that. If you took old Greek logic, you understand, but those arguments are going to be implemented, and, if A, then B, and, if B, then A, it's going to be those types of analytical logic that are going to be implemented that, so what it's going to, Zellner is going to be arguing if A, then B, and that's going to be primary burn site means bones were being brought back to Stevens' property, which makes zero sense. And then she's going to go, if A, then B, then C, which that points to actual innocence. The state is going to argue, and that's, very simplistic. And Erekose, all of the different things that support that, but and how to lay out the argument. But the state's going to come back and say it's flawed logic that just because the birth rate bumps up in September when the storks fly back into Amsterdam, doesn't mean that storks deliver babies. Yeah, A is true. The storks come back. B is true. There's a spike in the birth rate, which is probably more due to it being freaking cold in Amsterdam in January. And so the birth rate spikes in September.
Gotta keep warm somehow.
So, just because the storks return in September and the birth rates spike, storks, don't deliver babies. But
Right.
flawed logic can get you there. Well, that's what the state's going to argue, that,
I always expected the state was going to question her theory.
Yeah, and they didn't do a very good job of it at this point. I think those appellate attorneys in the Court of Appeals for the state going to be able to do a lot better job. But you'll see, in that motion, they talk about, quarter mile. They talk about, again, the technicalities, that it's supposed to be the who, what, when, where, and why. And Zellner has laid that out, the who, what, when, where, and why. Between the motion in the Court of Appeals for stay and remand, the supplemental motion she filed 11 days ago, it is all laid out there. I disagree that she hasn't complied with the technicalities of it. I do agree I anticipate a very lively debate on what the meaning is, but you see in there, they concede, even if they are, they try and make the argument, well, even if they are, her bones, the fact that they're in the quarry, I'm just like, how on earth can you argue that with a straight face? And they quote the trial transcripts.
Right.
They quote the opening statement, they quote the closing argument, and they're somehow trying, their main thread is a technical argument. But this is, one more example of what I was saying, that this is a type of thing may turn out good, that it's really going to require an evidentiary hearing to sort that out, right. Which is surprising. They filed it without being asked to do so.
Right. Okay. Allie asks, can the hall box be called to testify to clear up questions regarding these bones or whatever? For instance, how was it represented? How were these bones represented when they were given back to you? And that sort of stuff. Would that be? Is that
if Angie orders a hearing and allows witnesses to be called, yes, they could be subpoenaed.
Okay, there you go. Quick answer to that question. There you go. So
it'd be limited to whatever issues Angie identifies are, appropriate for the hearing. So if it's the what happened to the bones, what remains out of the bones, and what's the significance of losing those bones, I think somebody from the Hallback family, the person who handled whatever arrangements, would be an essential witness.
Right.
To even verify that they received the bones.
Right.
Fragments.
Right. Okay. So let's move on to the next part, which involves the state talking about the statute, which I find this part very interesting, folks. Seeing as I don't see what the hell the state, what state or what hair the state is splitting here. I'm not sure I'm seeing it. But anyway, here we go. So Avery cannot raise a statutory claim in a Wisconsin Statute 97-406 motion, but regardless, the state did not violate the Wisconsin statute. There you go, right? Disingenuous right on the face, guys. Right on front. Anyway, right on the tin. Anyway, Avery asserts the state violated Wisconsin Statute 968.205 when it returned bone fragments recovered during the investigation to the Hallbach family for burial in 2011. Avery is wrong. The state complied with the directives of Wisconsin Statute 968.205. Okay, so here they have a section of the statute here. Basically, it says, except as provided in sub 3, if physical evidence that is in possession of law enforcement agency includes, and they have underlined, any biological material, okay, any biological material. They underline that themselves, by the way, folks. That was collected in connection with the criminal investigation that resulted in a criminal conviction, which it did. Delinquency, adjudication, blah, 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 blah. Okay. And the biological material is from a victim of the offense that was the subject of the criminal investigation, or may reasonably be used to incriminate or exculpate any person for the offense, right? The law enforcement agency shall preserve the physical evidence until every person in custody as a result of the conviction, adjudication, or commitment has reached his or her discharge date. So they're saying that according to Wisconsin statute, they didn't violate this. That's what they're saying. And they're underlining all these parts, and the parts they're underlining show they did. You know, it's bizarre to read this in some point.
Well, that's what we were just talking about. So they're making this technical argument, and you know they make the logical argument, even if these are Teresa's bones, or even if they are human, Zellner has not shown how they could potentially be exculpatory, how they could exculpate somebody under the statute, or how they could inculpate Bobby or Scott, which it's true on that part. You know, it could raise an inference that it's clear this stuff was planted, and you know they would have the most motive to plant. But you know, this is stuff they're trying to argue so they don't have an evidentiary hearing. They're telling the court, well, just assume all this stuff is lost, assume it's Teresa's, assume it's human. It doesn't matter because Zellner hasn't shown you how this could be exculpatory. And
Right.
then you've already laid out, you know, why it would be exculpatory, that, you know, it undermines totally undermines confidence in the verdict. It blows their narrative completely out of the water.
Yeah, once again, right, absolutely.
And then number two, through the other experts, she's been able to establish her narrative that the primary burn site was somewhere other than the
Burn pit.
And so there's no way. So it is exculpatory because nobody would plant evidence on their own property.
Right. Which is pretty sound reasoning to me. If I had done something like that, I sure as heck wouldn't be putting the evidence of it on my front doorstep. And I don't think anybody would. Self-preservation would kind of preclude that, you know?
Unless you live in Hollywood and what was that movie? Kirk Douglas's son, Michael
Duffel bag or something like that.
No, Michael Douglas, and then the author, Sharon Stone.
Oh, Basic Instinct.
Yeah, and you know she writes a book,
Mm-hmm.
and it's got this plot, and so it was her. You know, they question her or interrogate her about that, and I guess she's the least likely to falsely confess, right? So she just, she said, "Well, I have to be awfully stupid to," and so then they start doing this reverse psychology, like, well, she wrote the book knowing she was going to do the murder that way, and that way that would kind of give her an alibi because, you know, she wouldn't be stupid enough to write about it. Anyway, who knows? You know, in Hollywood, they evidently think that you write out a whole murder you plan to commit in a book, and that somehow creates an alibi for you.
Right.
When you do it. And so Sharon Stone's character argued, no, it's clearly a copycat that was trying to set me up. They read my book and they did it, and they're out to get me.
Right. Okay, so the final section of this, folks, really is where they talk about this Andy rapid DNA testing, where they are basically making the argument that it is not really accepted for forensic testing on with they say it's fine. It's fine for like fresh buccal swabs when they're like bringing it in off the street or bringing a guy in off the street and they want to use this Andy rapid DNA testing, you know, there in the station or whatever to like quickly identify a perp or something like that. But what they're saying is that they're making the argument that it's not ready for testing of crime scene evidence yet. I'm not so sure I'm understanding the distinction there. Maybe Travis will understand that. But
well, it's that again. So yeah, it's preliminarily approved by the FBI working group to go into police stations. Someone's unwilling to give their ID, or they're unwilling to, or they suspect that they're not being candid, they can do this rapid testing, put them into CODIS and or the national database, and boom, it'll come back quick with fresh stuff. Right. And then, but they quote a position paper by the National Association of District Attorneys, and it says, yeah, we approve it for identification purposes, which is different than forensic purposes.
Right.
We approve it for identification in police stations, but not approving it for forensic purposes. But if you read in their brief, what they quote there, unless it's done by a
highly qualified, skilled.
And so who's the guy doing it here? The guy who invented rapid DNA, who has the patent on rapid DNA, the guy that identified burn victims in California, who says it's appropriate, and you know, I think I can get good reads. Well, their own position paper, so pretty stupid, you know, argument. Now there's
only in Disingenu-Wisconsin, folks.
So one thing I'm really interested in seeing Zellner's response. I think she's just going to concede it because it's not an issue, but it's an issue we all come back to outside of the legal context, sometimes in the legal context. But they mention in the brief that, you know, they don't mention Sherry Colhair's testing for DNA and the 9 alleles and
right.
that Loki that was a good match. They don't reference Sherry's testing. They reference the FBI testing.
Mitochondrial testing, right.
And they're very clear, and I've said this before, that test that FBI did with the shin bone looks like it's, and I don't know enough, you know, we'd need to talk more with an expert about it. And if we need to find one, I can find one to visit with about it. But I think the FBI mitochondrial test is valid. It has all of the indicators, but as we know, mitochondrial will only show that it is either the mother or grandmother of the individual or a child. And so since this was Teresa's mom, that bone came from a child of Teresa's mom.
Right.
And so that combined with other facts, that's a legitimate test. And it was interesting to me that they mentioned the FBI mitochondrial. They don't mention anything out of the Wisconsin lab. And I don't think Zellner's even going to touch that or get into it. I think I think her people have told her it's a good test, and that shin bone came from the child of, what's Teresa's mom's name? Karen. That bone came from a child of Karen Hallbach.
Right.
And, that's where I think the DNA is. We know for a fact that that shin bone came from a child of Karen Hallbach. And then you combine that with other facts, and, you can be confident or not confident in making those links. But that's one thing that kind of jumped out at me. They're distancing themselves from the Wisconsin lab testing on DNA, and they keep going back to the FBI. One was we sent 8675, the hip bones, along with other fragments, to the FBI, and they said they couldn't be tested. And so they're trying to say, hey, the FBI said it can't be done. What else are we supposed to do? The statute says exactly what you're supposed to do. Send a letter. We want to get rid of this stuff. And then the other thing they mentioned when it comes to the FBI lab is this mitochondrial DNA, and they're pretty forceful on it, that we sent a shin bone with the attached piece of whatever they called it, tissue,
right,
and it came back, and so they're representing that as solid DNA evidence. And I suspect Zellner's experts have told her it's solid, but we'd have to talk to somebody more about that.
Yeah. All right. So Scooby actually says something very funny here, talking about the questioning of the Andy quick DNA testing here. So Scooby says, they is okay with untrained law enforcement doing it to a convict of a crime, right? But not a well qualified scientist, right? I love it.
Yeah, that's great.
Great cat.
Tell Scooby to get his owner on and tell us about that mitochondrial statement.
We'll have to get Scoobs and the owner on here soon.
Yeah.
We've been meaning to. We've just been busy, so we've been having trouble connecting up. But we'll get there. She's a mitochondriac. Oh my gosh, she's making jokes now. Anyways, I think we're all requesting Scooby to explain the bones of DNA. Fine, here. I don't know if it's gonna work, but here it is. Scooby, are you even ready to come on? If I post this link, are you gonna tell me that you need to get dressed or ready or shower or anything? I mean, are you ready? Do you want to come on before we do all this? Otherwise, I'm inclined to do an entirely different episode about DNA with Scooby. So, either way. Okay, we'll do it another day, Scooby. We'll talk about DNA. We'll bring up this issue then. She's not ready to come on live. I didn't think she would be. Most anybody out there is not ready to come on live at a moment's notice. They usually need prep time. So, unless it's Travis. That dude's ready to go at a drop of a hat. Anyway. So
she can't do it tomorrow because we know what tomorrow is in Wisconsin, but Wednesday maybe.
What's tomorrow?
Tomorrow's a big day in
Oh,
Wisconsin.
yes, absolutely. I just realized what it is. So everybody's going out to vote tomorrow, right? Remember, we got 145 people watching at the moment, so I want to make sure I remind all of you.
Well, if they live in Wisconsin,
If you live in Wisconsin.
let's try to keep them out of prison. But
if you don't live in Wisconsin, remind people that do. Anyway.
Yeah, definitely.
Okay. But I'd love to have Scooby on anytime, but I'd like to do it when she's ready and comfortable to do so, because it's
Wednesday, and she could tell us about if it was good or bad weather to go to the polls, and I'd love to hear what she had to say about DNA and not how she voted, but what it was like at the polls.
She said she would have come on a half an hour ago. Okay, that boggles my mind. All right.
Wednesday. Maybe she had a couple of glasses of wine. Can't begrudge a couple of glasses of wine.
There you go. Hey, I'm about ready to have a couple beers. So, I'm drinking Blue Moon in honor of how long it will be before I ever believe any bullshit that comes out of the state of Wisconsin. Anyway, you ever seen that? You ever had Blue Moon?
Yeah, it's Coors.
It's Coors?
Yeah, it's Coors. Read the fine print. Coors Brewing. You thought you were getting a craft beer, and you're drinking Coors.
Yeah, well, it doesn't say Coors.
Yeah, it does.
It says Blue Moon Brewing Company.
Where?
Right on the side of the bottle here.
Okay, but where does it say it is?
Golden, Colorado, but anyway.
Oh,
next to the big building. Come on,
you fall for that marketing stuff all the time. You probably think Bartle and James are real people.
Beer tastes good though. It tastes better than
Coors. Yeah, it does taste good.
A lot better than Coors does, because I don't drink Coors.
No, it's good beer, no doubt about it. But Bartle and James aren't real people either.
Yeah. Oh, sorry. Say that one more time. I was trying to see something Scooby was writing.
Bartle and James are not real people.
Bartle and James. Yep. How about Ben and Jerry?
They're real. They're real.
They're real.
Yeah.
I freaking love their ice, especially the peanut butter cup. It's the peanut butter ice cream with the Reese's peanut butter cups in it. Oh my God. I'll eat a gallon of that. It's so good. I freaking love that stuff. So, all right. I guess we'll go back to the conclusion real quick. State's conclusion, folks. They say the defendant's motion for reversal of new trial cannot be brought in a Wisconsin Statute 974.06 motion. The state did not violate Wisconsin Statute 968.205. Yes, you did. Defendant's motion for new trial is replete with conclusory allegations and unsupported hypotheses, and the motion is deficiently pled. Lastly, the forensic testing contemplated in defendant's motion is not authorized or approved by the relevant forensic community. Therefore, the motion must be denied. Boo.
Heck, you could write Zellner's reply. Just yes, it did.
Yeah, I still don't know what hair they're splitting where they're trying to say they didn't violate that. It's like, no. I read everything you underlined, guys. You did exactly that.
Yeah, well, I'll just make that last comment I wrote the note about. So people have been watching that HBO 4-part documentary about
Anand
Saeed.
Serial.
Very, very good documentary. It's on the level of Making a Murderer. It's what you'd expect from HBO, and very, very high level. But the I don't want to, give away any spoilers, but it's a roller coaster ride, like similar Brendan's case. But the appellate lawyer, they get the thing reversed in the trial court, and same sort of thing. The state attorneys fighting tooth and nail to do that. They're talking about they made him an offer. He'd been in prison for 20 years. They made him an offer. If he pled guilty, he'd spend another 4 for a total of about 23 as it worked out. They turned that down, and then, they're going into the last phases of appeal. But again, I'm not going to give away the end, but the appellate attorney, just really good.
Right.
He says, we're in the driver's seat on this, but I'm still concerned because they're making the technical arguments that the state makes. They make the hyper technical arguments that, well, that may all be well and good, that this is a horrible injustice, but the post-conviction relief statute says it can't be a statutory violation.
Right.
And they make those arguments because there are certain types of judges who will, cloak themselves in that argument and, and say, well, I'm sorry, you need to talk to the legislature. I'm not going to write new law. I'm not going, says you can't do it. But, in this one, it's going to be interesting because the statute's real clear.
Yeah.
You don't do this. And their justification for it in the motion, part of which you went through, we didn't know, and he lost his motion for new trial in 2011, and so we thought it was all good. And
how could you expect us to hold on to every single piece of evidence collected?
Yeah, I mean, are we supposed to hang on to a ham Sammy for 20 years? And especially if the guy's got a life sentence? Oh, man. And what they don't mention is it didn't apply just to law enforcement agencies. There's identical statute for labs with evidence, for court clerks with evidence. And, the legislature was pretty clear. So to follow up on Allie's question, a great question. Yeah, we get a hearing on it, I think one of the Hallbox is going to have to testify, did they get the bones? To their knowledge, what happened with the bones? What did the state represent to you with regard to these bones? Did they advise you they were your daughters, or they suspected they were your daughter? What did they say? And then, because on paper, I think everybody agrees, on paper, it appears as though the state felt they were not only human, but they were Teresa's. Either that, or they're just really sick, evil people. I don't think Fallon or Gone are that way at all. I think they were trying to return what they could of Teresa to Teresa's family, albeit in total disregard of the statute. But I don't think they picked up a pile of stuff and gave it to that family, saying, well, maybe this will shut them up. I just hate to believe that, but following up on Allie's question, so Gone may be a good witness at the evidentiary hearing, calling him about, I'm a little disappointed. I mentioned this right from the get-go about the lack of legislative history in Zellner's motion. That could be because there's a lack of evidentiary hearing of legislative history. I just don't believe it. I think she needs to send a couple of interns to Madison and get every piece of paper she can on the statute and the amendment to the statute. But Gone, she could call Gone and say, hey, you helped write this thing.
Right.
You tell us under oath, what was the intent of this?
Right.
And then Tracy and I have talked about the amendment to the statute that the way it was amended is it was amended to be able for the state to get rid of evidence after notification. They added the part, hey, if you want to get rid of this stuff, you think it's not of any use, fire a letter off to the defendant in prison, or if he's represented by counsel, to his attorney. And if you don't hear anything within 30 days, you can do whatever you want with it. And that's why it was. You get rid of ham sandwiches and pizza and everything else.
Right. Okay. I think we covered it. So let me see if there's any actual questions we got here. Just everybody talking about wanting me to go on with Scooby at some point. Will do, folks. I'll get with Scooby someday. Well, her and I will have time to get together and do one. We'll do it. We'll get it done. See if there's any questions here.
So while we're looking for questions, I know this will come up. So the last go around, which was the court in reference to the computer disk and the Brady claim on that, Judge Angie denied that, and the Court of Appeals sent it back for that limited issue. And the state sent a letter saying, we intend to file a response and we're going to get it in by such and such a date. They filed it. Zellner had 30 days pursuant to that order. On this one that we're on now, they gave her 2 weeks. The one on the computer disk was 30 days. She filed it timely. The state said, we intend to file a response by such and such a date. They file a response. Zellner files a letter saying, we intend to file a reply. She files a reply, and then on, I believe it was September 7th of 2018, she issues a decision saying, as part of it, where she denies the motion without granting an evidentiary hearing on the computer disk, she says, nowhere in the very specific order of the Court of Appeals did the court allow for a reply brief by the state. First of all, the state doesn't file a reply; they file a response.
Right, and then Zellner files the reply.
State's not capitalized. This is just the quality of the person we're dealing with, or a response by the defendant. So at least at that time, she didn't understand that the state files a response and Zellner files a reply.
Right.
Therefore, the court did not consider the subsequent briefs, filed. So here, we haven't seen any type of briefing schedule, anything indicating she's going to order. So the question would be, when's her reply due? Well,
it technically isn't.
Right. There's no deadlines. She's got 90 days to file. She has 90 days from, quote, when the matter is finally submitted, unquote. So if she decided to hold a hearing and then asked after the hearing that both parties submit briefs, and she did a briefing schedule, and it would be motion, response, reply. I think that's when they're talking about once that reply is filed, it's fully submitted, and she has 90 days to render a decision. It's 90 days when finally submitted. Not it doesn't say 90 days from when Zellner filed her motion.
Okay. So
And
that 90
then,
day clock technically may not have even started yet. Probably hasn't.
correct. Now, Tracy may have found a case since the last time I talked to her about this specific issue that talks about what finally submitted means. But then there's this Supreme Court set of rules that govern how judges operate. And we've referenced this before, but it says, you have 90 days to, the judge has 90 days to submit their decision after it's been finally submitted, unless they send a letter to the chief judge, and it's not requesting time. They just have to send a letter to the chief judge saying they're going to take more time, and then they get another 90. And so there are no deadlines. So I really don't get wrapped up into trying to calculate deadlines, that sort of thing. It'll drive you nuts.
Right.
Because there aren't any. And so I suspect what will happen next is, if it were me, what I would do is I would file a motion to strike that response as being inappropriate, not allowed by the rules. You
And
can't file a
disingenuous.
response unless the court asks for one pursuant to 974.06 subparagraph 3A or B. Anyway, and then I would say in the alternative, defendants or petitioners reply and respond, reply to the state's response. And I'd send a letter that, hey, we're going to get ready and prepare, but it was pretty chicken shit of her. That's a legal term in Texas, by the way. It was pretty chicken shit of her to get these letters from both attorneys saying, we intend to file a response. It was Mark Williams. Remember, he sent the letter saying, and we're going to get it filed by July, whatever. And he sent it to the wrong place. He sent it to the court.
That guy gets his wires crossed quite a bit, doesn't he?
Yeah. Well, it'd be easy to get confused because she's in Sheboygan, correct? He sent it to the Sheboygan clerk. And technically, because it's out of the Manitowoc Circuit Court, you're supposed to send it to the Manitowoc clerk. And so, but Zellner sent it to the correct clerk, said, but I'll tell you, just about every other place they would, they'd give you a heads up and say, hey, even to avoid an ex parte communication, which is inappropriate, they have the clerk, call them up and say the rule says I don't need a response. You don't file a response until I request it. But they had these attorneys go to the effort and try and brief her and educate her and argue, and she just only values her time and her opinion. We call that black robe syndrome. Happens to a lot of people get elected or appointed judge, and which is the one downside to federal system, where it's a lifetime appointment unless you commit a high crime or misdemeanor and are subject to impeachment. But no, I mean, it's just it's clear why she's the fourth most requested judge to be substituted, even though she's from a tiny population-wise county. I bet she's close to number one if you did it on a per capita basis,
Right.
claims per thousand of population. But, but so the analogy about the oil tanker who apparently wasn't Mark Hod, but was the raving Scotsman.
The Capaldi.
She's still an iceberg, and she's still floating out there. And I can't predict what's going to happen. So people are asking, what do you think? What I think is they went hyper technical to avoid an evidentiary hearing. They specifically argue why an evidentiary hearing isn't needed. And, but I think because it's a lot of things they argued actually helped Zellner in her reply as to why an evidentiary hearing is absolutely essential. And so the next step is technically with Judge Angie, but Zellner can do some things. She could file a letter. She could file a motion to strike it. She could go ahead and just file a reply and send a letter saying I'm in the middle of filing a reply. But in terms of what the rule says, the response wasn't to be filed unless she requested it. So, we're waiting. Hopefully she'll say, yeah, we need a hearing.
Right. That'd be great. All right, folks. So I'm going to go ahead and we're going to go ahead and wind it down now. We're going to go ahead and listen to Disingenu-Wisconsin on the way out. Those of you guys who know Roll, he's awesome. He wrote it. And I just think it's awesome because I love how clever he was with it. So I'm going to play that for you guys as we go out, And hi, Travis. Thank you for being here, obviously, and bringing us your knowledge and expertise.
Thanks for having me. It's my pleasure. Good seeing everybody. Hope you have a good night. If you live in Wisconsin, remember tomorrow's voting day, 7:30 to seems like it's early there, but they have to give you time off from work. And even if you aren't registered, if you have a driver's license, doesn't even have to be a current address, a passport, doesn't even have to be a current address. That can't be expired, but they,
valid IDs,
you could even have a nickname, it says. So if your name is, if your name's Patsy, and your driver's license says Pat, and
so
you're registered.
Use my passport if I lived in Wisconsin. Right on. Cool.
Yep. So, get out there. If you know people that live in Wisconsin and they're eligible to vote, you just bring a current driver's license or government ID and proof of your residence, which can be a phone bill, gas bill, and you can even show that with, if you don't get paper bills, you can show them that through a smartphone. And if you have kids going to college, the great University of Wisconsin, all those great schools up there, if you have kids up there, they're eligible to vote. They just need a Wisconsin driver's license, and they need to show, again, by their phone, that, their current class schedule, that they're enrolled in school right now. So hopefully we'll get a good turnout tomorrow for the spring election.
All right. You heard the man, folks.
You.
All righty, here we go.
They say that Stephen lured her to the yacht and T.H. had no address. Bliss colliding court, but Teresa, she surely did not have to guess. all those voicemails to the zipper. Somehow Jacobs lost them all, but one of them turned out to be a replacement for the Yandercall. In this case, we surely see a wicked voicemail gate. These kind of things can only happen in the state of Disingenu-Wisconsin. They said it was too dark to see any blood in the car at Avery Yard, but they were able to read the text on that teeny-weeny SD card. They said because it's locked we cannot explore inside of that RAV4. When it arrived at the lab, they suddenly Sesame opened the driver door. How it got there, wrong way round, that does need no debate. These kind of possible things only happen in the state of Disingenu-Wisconsin. They said that Bushman was just helping us volunteer. But anyway, why was he in charge of all of those cups on that important day? 'Cause Road was a gift to draw all attention away from ASY. Bushman wrote no report, so we can just guess the actions of this guy. Next day, all important stuff was found, November 8th. This kind of staging can only happen in the state of Disingenu-Wisconsin. They say those bones were found in Stephen's pit, and we saw those photos made. But for some weird reason, all of them did somehow evaporate. Now Deborah Kakach would certainly have put on there a diesel grate, but she was withheld by the sheriff from scrutinizing Stephen's pit. Willis could not see the relevance. Well, you're blind and mate. This kind of trap can only happen in the state of Disingenu-Wisconsin.
I love roll.
They say that Stephen's DNA was obtained from that Toyota key. Sure looks like a magic thing, because why would it be TH-free? The key was found after heavily shaking that wooden thing near Stephen's bed. But somehow all those coins remained where they were, as if glued to the cabinet. I think they didn't get the order of these photos straight. This kind of swapping is only allowed in the state of Disingenu-Wisconsin. They say that Brendan was no suspect, they needed just some witness quotes. Investigators did an interview, but why then those Miranda notes? They say their storyline was made out of facts provided by his team. But on each question he gave 4 answers, at least for them to choose between. Guessing until it matched what Bert and Ernie did create. This kind of BS can only happen in the state of Disingenu-Wisconsin. They say reports on items sent to the FBI were all sent through, but somehow they forgot the possibly exculpatory thing Q2. They said the garage was clean, so that's why they did not find Teresa's blood. But that concrete was tested and it had Stephen's blood. Okay, now what? Miracle bleach that kills only female blood. That must be great. These kind of miracles only happen in the state of Disingenu-Wisconsin. They said they had the bones available for the rapid DNA. Well, it turned out the bag was empty. They threw the bones in bad faith away. Violation of due process and probably also destitute. Evidence handling evidently is in this county clearly screwed. Case or ledger full of holes with things that don't relate. This kind of sloppiness only happens in the state of Disingenu-Wisconsin. Disingenuosity continuing up to date. Steve and Brendan both got screwed by the state of Disingenu-Wisconsin. Disingenu-Wisconsin. Disingenu-Wisconsin.
Oh, nice. I like it. Folks, if you don't know who that is, that's Roll Griffin. He is he's one of the wrecking crew. He's brilliant. He's a very good researcher, very sharp individual, and as you can tell, somewhat multi-talented. So I love it. Yeah, the way he made Disingenu-Wisconsin, I am like jealous. I didn't think of that first. Anyway, so that's about it for today, folks. If you haven't already, please hit subscribe. Everybody be looking out around the end of April. We're going to be doing a weekend, whole entire weekend where me and Allie, Tracy, Paul Capaldi, maybe even Mark Hodnott and stuff, that we're going to be handing off the lives. We're going to be, we're going to start going live from like 12 a.m. on Saturday morning, which is basically Friday night, right? And we're going to start going live, and we're going to go all the way till midnight on Sunday. We're going to try to keep handing it off. So there will always be one of us live during that weekend. It's going to be at the end of April, folks. Look out for that. We're working on the planning of that right now, so keep that in mind. Everybody, if you haven't, go over and check out that link to Roll's, song here. Subscribe to his channel, all that sort of stuff. And like I said, if you haven't already, please hit subscribe, and we'll see you.